It's pointless to send you to jail. It's pointless. It's pointless to send him to jail. And it costs the county, I think it's up to $60 a day now. I think we're counting $60 a day to house an inmate. You're costing us money. No one had your children but you. And you're making other people and other things support your children. What is it going to take, Mr. Wooler? What is it going to take? Interest, blah, 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 blah. When you don't pay, this is what happens. And I'm asking you, what will it take? What will it take? You're doing nothing. Well, I'll move on. Who do I have here? Do I have Lexi Benjamin? Michelle Ingstrand? Jonathan Erdman? Dirk? How do you say your last name?
Bomsel.
Oh, the H is silent. Bomsel. And Timothy Nelson? Excellent. All right, let's start with Mr. Erdman. We will go on the record in the matter 26 CT 20 State of Wisconsin versus Jonathan Erdman. The state appears through District Attorney Kevin Schmidt in person. It worked or not?
It might be maintenance.
Mr. Erdman appears in person without counsel. We're set today in this matter for an initial appearance. Mr. Erdman, did you get a copy of that criminal complaint?
Yes, I did.
And can you read, write, and you understand the English
Yes.
language? Do you need me to read that charge and the maximum penalties to you?
No, you don't.
Do you need me to read anything else on that complaint to you?
No, you don't.
You fully understand?
Yes, I do.
Are you on 1898 12th and a half Avenue,
Yes.
number 33?
Yes.
Can I get a telephone, please?
715-939-2106.
May we send you text message notifications?
Yes.
All right. Not guilty plea will be entered on your behalf. You are entitled to a jury trial. You would be entitled to a speedy trial should you request one. Are you in the process of getting your license?
Yes, I've been in contact with I gotta buy a car because I have to have a car in my own name. Because then,
The ignition airlock?
right, for a year.
Okay, and so that's all that you have to do, or do you have to do the AODA, OWI
No, I had
assessment?
that from the original one. What had happened is all the charges got dropped. And then about 8 months later, they charged me with the refusal because I was in my own yard. I wasn't doing anything. And they charged me a $50 ticket for refusal. I went and got my license. I went through everything for all these charges. And then I was sent to Minnesota for training. They sent me the court date on a Friday and had me show up for court on a Wednesday when I was gone.
Oh.
So
Okay,
then
bummer.
I didn't know it was done until about 3 months ago when I lost my driver's license. I literally lost it. I went to the DMV and I went, what? So then that's what I've been dealing with. Now I got to buy a car, get the insurance, the interlock and everything to get my license back.
Oh, I'm sorry to hear that. Okay, so how long do you think it'll take you to get that?
About 3 months.
3 months? What is the offer, Mr. Schmidt?
Well, my offer is plead to OAR for costs. His driving record, as we ran it just 2 months ago, says he's disqualified for life.
No,
So
because
you lifted that?
they said I had a CDL. I do not have a CDL and I haven't had a CDL since 2002. And that's what showed up on my record.
If he is able to get his license, would it be dismissed?
I guess, but Wisconsin thinks that he had a refusal in 2019 and revoked him for the rest of his life for that.
No, they're saying that was because of on there, it says, even on there, it says on the paperwork that I had a CDL. I haven't had a CDL since 2002.
Okay, so you have some things to clear up with the
Yeah.
DMV.
Right.
All right, so the offer would be, if you are able to get your license, it would be dismissed. If it comes back and says you can't get your license, then it would be plead to the charge just for costs,
Okay.
for court costs, okay? So I can give you a few months to be able to see if you can
Yeah.
work that out,
Okay,
because I want you to have your license if you're able to get it.
Yeah.
If not, then it's unfortunate. September 8th at 9:30, okay?
alrighty.
So you can come up here and then you will get a notice, but September 8th at 9:30, all right? We'll see you then.
Thank you, Your Honor.
Thank you. Please make sure your phones are muted.
Oh, yeah.
Over here.
I don't get this stupid door.
Yeah.
I guess we should tape it.
I just tape
If
the
I
door
give you
down.
tape, can you go tape it?
You have tape?
I don't, all I have is this tape, but that should work, right?
I could just go to maintenance.
I messaged.
Maintenance should be coming soon, or does it prop open? Is there a little proper open thing? Like a door thing?
That's
Door's
gonna attract a lot of names, a lot of sound.
I don't care today. I'd rather have that than go, okay, please, kind sir, who's waiting to be heard on your case? Can you open the door?
I could try with the bat.
We will go on the record in the matter 26 CT 23, State of Wisconsin versus Dirk Vamsel. The state appears through District Attorney Kevin Schmidt in person. Mr. Vamsel appears in person without counsel. We're set today in this matter for an initial appearance. Mr. Vamsel, did you receive a copy of that criminal complaint?
I picked it up in person here at the county clerk office, yes.
And can you read, write, you understand the English language?
Yes, ma'am.
Do you need me to read those charges to you and the maximum penalties, or do you understand them?
I understand that.
Do you need me to read anything on that complaint to you?
Nope,
Are you still on Frog Hollow Court?
correct,
Telephone ends in 9290.
correct.
Not guilty plea will be entered on your behalf. You are entitled to a jury trial. You would be entitled to a speedy trial should you request one. Are you in the process of getting your license?
Yes, Minnesota has a hold on it and I put in the application to see what needs done on that end and what courses they need me to take.
Okay. And then it looks like here on Wisconsin side, you'll have to figure out the Minnesota side. It's
Yep.
really not, sometimes it's hard.
It's not fun.
It's not, especially when you're dealing with Minnesota stuff and Wisconsin stuff. It makes it a tremendous hassle. And it should be easier because we want people to get their license.
Yeah, yeah,
So I understand, but you need to take care of your Minnesota stuff. And it looks like here in Wisconsin, then you're gonna need to get what's called an AODA OWI assessment.
Yep.
And driver safety plan.
Yep.
And then an ignition interlock device.
correct.
On
And
your
SR
vehicle.
22 insurance.
Right,
Yep.
you know the drill, you know it all. Okay, good. So it's most likely gonna take you some time. But do you have an idea of how long it's gonna take you to try and clear up the Minnesota side at least?
Well, without being able to drive and ask for rides to gain the money to get to work, that is tentative and not able to gain the money immediately. I'm hoping to have it done in 6 months. Just, I can't financially pay for it all immediately.
And I understand that. And I'm willing to give you time. I know the state's willing to give you time. We just can't, when it gets
Yeah.
close to a year, that's getting way too long.
Yeah,
But 6 months sounds reasonable. What is the offer if he gets his license?
If he gets his license, we'll dismiss.
It'll be dismissed if you get the license. If you can't, or you're like, you know what, this is a lot of work and I need a lot more time, it would most likely be to plead to the charge for costs.
yeah, and Your Honor, I just, trying to avoid that as well. I'm on probation in Minnesota for the original charge. So if it gets criminally charged, it kind of throws a wrench in the whole operation.
We don't want that. So when were you charged in Minnesota and convicted?
Mother's Day of 2025.
Happy Mother's Day to your mom. I bet she was not too,
Yeah, she was none too pleased.
okay, and so what was the deal there?
Seeing my mother drinking and got pulled over.
You on a tizzy?
Yeah,
Okay. All right, so I'm gonna do September 8th at 9:30. You're totally fine to appear by telephone or by, do you know how to do Zoom?
yeah.
Okay,
can do that.
either one, because then you don't have to drive from Minong. I'd
Well,
rather-
I'm not driving. I got a ride here this morning.
I
so,
love that too, and that's, you don't need to get a ride from Minong.
Yeah,
September 8th
yeah,
at 9:30. So I much rather have you save that ride for a next time.
Yeah.
And they save their money or your money paying
Yeah,
back
I
gas,
gotta pay
okay?
him $20 just to get here.
So phone or Zoom is fine. I just need to know where you are in that process, how much progress you've made,
Okay,
okay? Please make sure you continue to do the things and you have made some accomplishments on some of those steps.
absolutely.
All right.
Like I said, the application's put in to see what courses I need to do. That's paid for.
Excellent. Come get your notice and it should have that information on and you're free to go.
Thank you, Your Honor.
Thank you. Who's in custody? Who's in jail? Can you hear me?
Yeah,
Okay, because I'm not a ghost. All right. So who are you?
Rihanna.
Indiana. I don't believe we have her on my, I don't believe you're on my schedule.
Let
Let me just look. Brianna. Nope, you're not until June 22nd, okay?
Oh, she had.
Just let me
Oh,
in
wait,
here.
just wait. There's an intake. Oh, it's an intake with Amy. Is it just for like a not guilty plea or something?
It's a village ordinance.
Village ordinance, okay. So it's 26 FO 141, Village of Siren versus Rihanna Johnson. I'm gonna call it and then we'll just transfer it. You don't have to do it. I'll just tell Amy. We will go on the record in the matter 26 FO 141, Village of Siren versus Rihanna Johnson. This is a village ordinance for disorderly conduct. It's a ticket. And so at this time, do you wish to enter a not guilty plea, Ms. Johnson?
Yeah,
All right, the court will enter a not guilty plea on your behalf. And have this matter track with your other cases, your other case. And so we'll see you back on June 22nd at 3:15, okay?
okay.
All right, thank you.
Yep.
We just kind of need it on the record. We don't really need minutes or anything, but I just wanted to make sure it's on the record so we know that it can be a not guilty and track. But I didn't mean to like throw it on you. Mr. Nelson? Just let me know when you're ready. In a minute. You're good. We will go on the record in the matter 26 CT12, State of Wisconsin versus Timothy Nelson. The state appears through District Attorney Kevin Schmidt in person. Mr. Nelson appears in person without counsel. We're set here today in this matter for an initial appearance. Mr. Nelson, did you receive a copy of that criminal complaint?
I did not.
Would you like a copy? Mr. Schmidt can give that to you right now.
Yes, please.
And since you did not receive a copy earlier, either I can go over it with you to make sure that you understand that, or I can give you another date to come back to give you some time to read it yourself, to process it, to do those things. What would you like to do?
You can go over it quick if that's possible.
It's totally possible and it's fine. So it alleges one count, and if you look on page 1, it's operating a motor vehicle while revoked. It alleges on or around February 12th, 2026 in Burnett County, Wisconsin, while being a person whose operating privileges have been revoked pursuant to Wisconsin law, you operated a motor vehicle on a highway during such revocation period or thereafter, and that revocation resulted from an OWI or similar offense. This is a misdemeanor. You shall be fined not more than $2,500 and imprisoned not more than 1 year in the county jail or both. Do you understand that count and that maximum penalty?
Yep.
Do you need me to read anything else on that document, or do you think you'd be able to fully understand it?
I think we're good.
Okay. Are you still on State Road 87?
Yep.
Does your telephone number end in 9178?
Correct.
May we send you text message notifications?
Yes.
Not guilty plea will be entered on your behalf. You are entitled to a jury trial. You would be entitled to a speedy trial should you request one. Are you in the process of getting your license?
Yes, I have actually my first counseling appointment today.
Excellent. So you must have had your AODA assessment. And so did they give you an idea of you need 4 sessions, you need to do this?
Well, I think it was like 5 sessions maybe.
Okay,
Yeah.
and every week? Every other?
Just whenever they're the next available, basically.
All right, so what I'm going to do, well, first offer, if he gets his license, it's dismissed.
If he gets his license, we will dismiss it.
So it'll go away if you get your license. If by chance something comes up and you can't get your license, it would be plead to the charge for costs. But it sounds like you're doing what you need to do. I'm very happy to hear that. September 8th at 9:30. September 8th at 9:30. If you get your license before then, because it's always possible. So if you get your license before then, take it to Mr. Schmidt's office. You know where the elevators are, you go the opposite end of the hallway, almost to the end on the right, and you show them a copy of your license and you won't need to come back.
Okay,
Okay? So you can come up here and get your notice and you're free to leave.
sounds good. Thank you.
Ms. Ingstrand? There you go.
Thank you very much.
We will go on the record in the matter 26 CF 48, 26 TR 297, State of Wisconsin versus Michelle Ingstrand. The state appears through District Attorney Kevin Schmidt in person. Ms. Ingstrand appears in person without counsel. We're set here today in these matters for initial appearances. Ms. Ingstrand, did you receive a copy of that criminal complaint?
No, I didn't.
Mr. Schmidt, he has a copy. He will give it to you right now. It alleges 2 counts. Well, the criminal complaint alleges 1 count, possession of THC second. It alleges on or around April 17, 2026, you possessed a substance. The substance was a controlled substance, THC, and it would be your second or subsequent offense. It's a Class I felony. Upon conviction, you face a fine of up to $10,000 or imprisonment of up to 3.5 years or both. And the TR matter is operating a motor vehicle without proof of insurance. Do you need me to read any of that out loud to you other than providing that charge and the maximum penalty?
I thought it was a state. A city ordinance, a state.
It is not. You may have gotten a ticket, but the state, Mr. Schmidt, the district attorney, he gets final decision-making authority on whether or not to charge this. But right now, do you need me to read it to you?
No,
Now, right now, I'm going to ask him before you want to consider if you want an attorney or you don't want an attorney. Is there an offer that can be presented to Ms. Ingstrand?
The offer in this case is if she pleads to misdemeanor possession at THC, we'd read in the traffic ticket and do everything for costs.
All right, so what he's saying is plead to a misdemeanor version of possession of THC. It would be amended from a felony to a misdemeanor, and the other ticket would be dismissed.
I
And for
haven't.
costs only.
I have insurance. I just didn't have proof of it at the time.
Oh, well, that's good that you can provide him proof.
Yeah.
So that one should be taken care of. But with regards to the THC, then it would be amend from a felony to a misdemeanor for costs only, not for any recommendation for jail time.
Yeah.
So, would you like to consider that offer and consider whether or not you wish to retain an attorney?
Yes.
Okay, what I need you to do, I know you've qualified for a public defender before.
Mhm.
You need to reach out to the public defender's office and see if you qualify again. And if you do, they will appoint somebody to you.
Okay.
Right now, I'll enter a not guilty plea on your behalf. I am going to set this for a preliminary hearing. Do you wish to have it within 20 days or do you want some extra time to be able to get an attorney?
Within 20 days.
Within 20 days? That may make it more difficult to get an attorney.
Will it?
So we can set it for 20 days. And if you don't have an attorney, then we can consider maybe moving it. We will get notice that you're looking for an attorney. But right now they are overloaded with cases.
Oh, we can push it out if you want.
So you can,
If you think-
we'll waive time limits. Okay, but then I will make sure to get it as close as I can with knowing their availability. So hopefully we can get this looked at with you sooner rather than later. Excuse me. Does July 7th sound like it could work?
Yeah.
July 7th at, let's do 11 o'clock, July 7th at 11. So you can come up here and get your notice. It says I need fingerprints. So you're gonna get your notice and then you'll get a form for fingerprints and then you need to go to jail intake and just provide your fingerprints. The law requires that we get fingerprints for every single case, open case, okay?
Yep.
So you can come get your notice and your paper for fingerprints and you're free to go.
So I don't have to go over to the window for the no insurance?
Well, that's something you would have to give to Mr. Schmidt's office. If you have proof of insurance today, you can take it to his office and they'll make note of that.
Okay.
Okay? You do not have Lexi Benjamin? No. We will go on the record in the matter 26 CT 17, State of Wisconsin versus Lexi Benjamin. The state appears through District Attorney Kevin Schmidt in person. Ms. Benjamin fails to appear. This matter was set for 10 o'clock. It is now 10:18. The weather and driving conditions are good, but it does say that we have return of mail. We were unable to reach Lexi Benjamin at her last known address. So at this time, are you asking for an arrest warrant due to the inability to serve, or are you requesting additional time to try and serve?
I'd ask for a warrant.
The court will issue a warrant. $200 cash, only judge may quash or posting of the cash. Who's in custody?
Probably Colton Stewart.
Colton Stewart. Patrick.
You'll have to spell out the case numbers for me.
Sure, which ones are which?
Mr. Stewart's is sort of an interesting one today.
Who is by video, or who is in the neon yellow green?
Justin Erickson.
Erickson.
And he does have permission to appear by Zoom.
Okay. Let's do Mr. Erickson first. Then we'll move on to all, whomever you wish to go to.
Sent me this morning, copies of snooze paper. There's no date on it or anything, but it's a case.
Okay. We will go on the record in the matter 18 PA 1 PJ in re the paternity of Z8E. Appearances are we do have Justin Erickson appearing by video conferencing with approval of the court. Stephanie Thomas Schmidt, Corporation Counsel, appears in person. We're set today in this matter for a motion hearing. Ms. Thomas Schmidt, please update the court.
Your Honor, this is a continued hearing from last month. Mr. Erickson is in a sort of unique situation with the department, or the agency. He has pulled some things together and is doing well, is employed. And what our historical trend for Mr. Erickson lately has been, when he's come into court, when he has this added incentive, added pressure, he is able to hold things together, pull things together. So at the last hearing, we requested, and it was ordered, that Mr. Erickson return monthly for a period of time to ensure compliance and to keep that added incentive, added pressure. Since the last time Mr. Erickson was in court, he has maintained his employment that he had just obtained with Taylor Freck. He was also to provide us copies of his pay stubs verifying that child support was coming out. And if child support was not listed as a deduction on his pay stub, to self-pay. Mr. Erickson has provided us copies of both pay stubs that he's received thus far, with child support listed as a deduction on that pay stub. So Mr. Erickson is doing exactly what he needs to do right now.
Well, that's good. All right. Excellent. Okay, so in your opinion, do you believe that we should set this for another hearing sometime out? You just want to wait and see if he's going to be working with child support?
My original intention was 3 to 4 months of consistent court appearances to build that consistency, to build that stability, such that we can remove some of that extra supervision and have continued success for Mr. Erickson. That being said, I wouldn't be opposed to setting the next review in August instead of in July, giving him a period of 2 months to keep things together instead of checking in at the 1 month basis. And that date would be August 12th.
All right, we can schedule him for August 12th at 10:30. August 12th at 10:30, Mr. Erickson, if you are compliant with child support, that means you're doing what you need to do. You can appear by video like you've done here today, okay?
I appreciate that. Can I, if at all possible, can I make one request? I switched to nights this coming Monday. So like, afternoon would be better because I'm probably going to be sleeping until noon, 1 o'clock-ish. I mean, if not, I can set 10 alarms and make sure I'm up, but I'll be working 6 p.m. to 6 a.m.
Well, Mr. Erickson, we set you in, it's called a child support sanction block.
Okay.
So it would be, if it's a special request and Ms. Thomas Schmidt can accommodate, I wouldn't be opposed to a different time.
Yeah, it's not,
I guess
it's not the end of
my-
the world if I got to wake up a little early and do this. It doesn't take long and it's not that big a hassle. I just, if it works with you guys.
Ms. Schmidt.
I guess my thought is that if Mr. Erickson has perfect compliance, every pay stub gets sent, it's deducted on every pay stub between now and that hearing. We could discuss removing the hearing if he's compliant.
All right, so we'll leave it on as it is. If you
Okay.
are completely compliant, you've done all that you need to do, you're still working, still paying your child support, all of those things, and you're in contact with child support, then we can remove it.
And providing the pay stubs.
And pay stubs.
All right. Is that the format I'm sending those in, just the screenshots that's working out?
We don't
Um,
have the date. We need to make sure that we see all the pertinent information, the date, how many hours you've been working, the
right,
money
yeah,
that's
I
been
just-
deducted.
I took screenshots because our payroll is on like an app. So I just took screenshots and sent them to Deanna. And
Yep.
I didn't know if the format worked out with her.
That works. Just try to make sure you capture everything in your screenshot.
Okay.
And if you
Understood.
have to, sometimes with the screenshot, you can't get everything in because you have to move the screen. You would have to double screenshot, then take a top
All right.
and then take a bottom and send them both. Okay?
I'll make sure.
All right, sounds good. Thank you, Mr. Erickson. We're adjourned.
Thank you.
Would you like to do Colton Stewart?
Sure.
And that's only 25 FA15, correct? Yes, Your Honor.
I believe so.
I need to wait.
If we could give it, I think we can start.
We will go on the record in the matter 25 FA15, in re the support or maintenance of IRES. Appearances are, we have Colton Stewart appearing by video conferencing in custody in Burnett County Jail. We have Corporation Counsel Stephanie Thomas Schmidt in person. We're set today in this matter for a sanctions hearing. Mr. Stewart was found in contempt and on April 8th, 2026. No, he wasn't in court on his motion hearing on April 8th, 2026. He was found in contempt on December 4th, 2025. He has failed to meet his purge conditions. Ms. Thomas Schmidt.
Your Honor, interestingly, in this case, the custodial parent, Ms. Ricci, forgave all arrears owed to her and ended support as of yesterday afternoon. That stipulation was filed. So Mr. Stewart's balance is approximately $130. If I'm I could be a few dollars off. I believe that's what I read, owed to the state. Given that, certainly we would request that the warrant be quashed. It was a warrant for non-appearance at sanctions. I've been told that Mr. Stewart may have some other matters that might complicate his life for a period of time. So I guess my request is that the warrant be quashed, the contempt finding, the purge be modified from paying current support to paying a minimum of $25 per month on that arrearage owed to the state, to last for a period of 1 year, to take effect the first of the month following Mr. Stewart's release from his current incarceration situation.
Ms. Sherwood, do you represent Mr. Stewart?
I do, Your Honor.
Okay, I don't have
Only in
it
this
listed.
matter.
What?
Only in this matter, not his criminal matters.
Okay. Yeah, I don't have it. You listed as being retained in this matter.
Oh,
Mr. Stewart, so what I'm hearing is that there's an amount of 130 some odd dollars that's owed. Is that something that you would be able to pay off in one lump sum?
Today, but yes.
But, so when do you think you'd be able to pay off that amount in total?
In a month.
In a month? All
Yes,
right.
ma'am.
So, Ms. Sherwood, sound agreeable?
yes, Your Honor.
The court, the warrant is quashed, and what the court's going to do is vacate that $2,000 that the court had ordered to be paid for his release. What I am going to order, though, is that $130 be paid no later than July 30th, okay? No later than July 30th in full. So Ms. Sherwood will need to find out the exact amount that's owed. She will let you know, and then make sure that's paid by July 30th. If it is not paid by then the court could issue sanctions. Actually, what I'm going to do is I will issue sanctions. If you don't pay it by then, you're going to have 5 days in jail. Okay?
Good.
Then we don't have to mess with 25 here, 25 there, add interest, do this, all of that.
Right.
All right?
And I think as it's the fees owed to the state, that's not interest bearing,
Oh, all
but
right.
still,
Either way, then the state can be paid, still cost the state interest,
it does.
cost money. So, just have it paid by the end of July 30th, okay?
Okay.
All right, thank you.
Thank you, Your Honor.
Thank you. Who would you like next?
Joshua Waller,
Mr. Waller.
which is 2018 FA 80. In re the support of GDW.
We will go on the record in the matter 18 FA 80. In re the support and maintenance of GDW. appearances are, we do have Joshua Waller appearing in person without counsel. We have Stephanie Thomas Schmidt in person, Corporation Counsel for Child Support. We're set today in this matter for a motion hearing. This is a motion to lift the stay on the court's jail sanction that was ordered. We were here on February 12th, 2026, in which certain requirements and purge conditions were set on the record, and Mr. Wooler was informed of those and agreed and stipulated to those. He has failed to meet those conditions. Ms. Thomas Schmidt.
Your Honor, Mr. Wooler is under an order to pay $138.46 per week current support, $5.77 per week arrearage support. Since March 1st, he has paid a grand total of $40. He was also under an order to do work searches, 2 applications per week, making contact with child support twice monthly with updates. And that has significantly not happened either. Mr. Wooler contacted child support on April 23rd, stating he was working for Troy, Maine, that Troy, Maine would not do income withholding, and that Mr. Wooler would make payments on his own on Mondays. And he very much did not do those things. He did not turn in any work searches. I don't know what he's been doing, but he has not been doing what the court has required of him in compliance with his child support order. And for those reasons, I'm asking to lift the stay on the totality of the 90 days.
Mr. Wooler, you've been here before. I went over the fact that you do have a right to an attorney, or you can represent yourself. I believe you have always represented yourself. You were here in February. You knew the risks, you knew the sanctions, you knew the penalties. Why aren't you making good on your promises?
Well, I started working with Troy up there, and then I only had one vehicle to use, and then
I'm gonna have to ask you to make sure that the microphone is closer to you, and you need to enunciate your words. It's kind of mumbly, and if I can't hear it, my court reporter can't hear it, and we can't make sure that everything is down.
Okay. All right. I started working with Troy, Maine, and then the vehicle that I had, only vehicle I had, it's in the shop now, but I mean, I couldn't get up there. I didn't get paid for the time that I could get up there yet. And
So you don't have a job?
no, I couldn't get back up there.
What?
I couldn't get back up there. It's like a 40-minute drive from my house.
Okay,
And
where do you live?
right on 70 here by Whiskey Joe's.
Live by Whiskey Joe's?
Yeah.
Have you applied at Whiskey Joe's?
No, that's where I live, right by there.
Yeah, have you applied there?
Oh, no, I don't know if they're hiring.
Oh, have you asked?
No, I did not.
What about down the road at Knotty Pine? Have you asked?
No.
So you haven't asked, and you haven't looked to see if they were looking for any service?
They weren't in the paper, those places. I look in the paper, dude.
Here's the thing, papers are dead, okay? Not everybody does this, and I think I went over this with you before. I was called old for reading the paper, okay? Because that is my Sunday thing. Have my cup of coffee, open up the paper, read it. But you know, the paper used to be like 30 pages. It's 5 now. You can't find all of the ads in the paper. You have to physically get up and walk to businesses. Hey, Ace Hardware, are you hiring? Hey, Whiskey Joe's, are you hiring? Hey, Knotty Pines, are you hiring? Those are, well, at least the 2 bar and grill places are places that you can walk to where you live. You haven't put out any effort. Have you located the Clam Lake Association? Maybe they're looking for somebody to work at the boat launch to make sure that all of the invasive species are removed from all of the boats that go in and out, because, you know, we have an issue with that. I know that they hire people to do that. I know that for a fact.
I didn't know that was a thing. Like, I don't know.
It is a thing.
Okay.
You can make good money doing it. So those are, you gotta think outside of the box. Okay? So you lost your job or were unable to get up there since March?
Since, yeah. I mean, I don't have a vehicle. I can't, I don't know anyone else with a vehicle.
When
Like,
was the last day you worked with Troy Maine and your car blew?
I don't exactly know the date.
Give me a guess.
It's in April sometime,
April. April 7th,
the middle of the month.
April 15th. We'll go with April 15th.
Okay.
I'll give you the benefit of the doubt. April 15th. April 15th, May 15th, June 15th, almost 2 months. 2 months. And so what have you been doing with your time? What's your normal day?
My mom's been on bed rest and she has cancer. I'm the only one that can help her right now. And
I think we went over that before too, that you can talk to ADRC and see about classes and whatnot to be able to be a caretaker and get paid to do that. I think actually that was one of your excuses that you had one of the times you were in custody, that you were going to do that with one of your friends from the tribe, correct? Am I remembering correctly?
yeah, he went to jail though, and then
I know, but I'm just saying,
I,
I'm not saying that you needed to do that. I'm saying ding, ding, ding. You knew that's an
Okay.
option and something you can do. I've went over that with you before. Have you went to ADRC and have you looked into that as an option?
I looked, I didn't call though. I didn't have a phone at the time, but
I think the last time you were here, I said, walk your little legs down and go to their little office and say, hey, I'd like to talk to you. Because you're here in the building, they're in the building. And that was in February. 90 days. It's pointless to send you to jail. It's pointless. It's pointless to send him to jail because it doesn't teach you a lesson. You just get 3 hots and a cot. You just get to have some mingling and socializing time. It doesn't make you go, hey, I need a job and I don't want to do this again. It doesn't allow you to get a job for 90 days to pay your child support. And it costs the county, I think it's up to $60 a day now. I think we're counting $60 a day to house an inmate. You're costing us money. No one had your children but you. And you're making other people and other things support your children. What is it going to take, Mr. Wooler? What is it going to take?
I don't know what to say. I really don't. Like,
I think there's around 10 grand in arrears.
21,850.
Ooh, that hurts my belly because that's a lot of interest. It's a lot of interest. Back in 2024 it was around 8,500, I think. And now interest, blah, 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 blah. When you don't pay, this is what happens. And I'm asking you, what will it take? What will it take?
I don't know. I don't know what to say, but it's,
You know, I know a gentleman who lost his license, and I don't know, this has to be 10, 15 years ago, lost his license for doing some dumb stuff, rides his bike 10 miles to work every day. 10 miles, I think it's maybe even more than 10 miles every day, even in the winter. Even in the winter, rides his bike to work, to make money, to support himself and his family and all of the things. Like, that's incredible. That's respectful. You're doing nothing. Court is lifting the stay 90 days. There's no reasonable excuse. There's no
my mom has
reason.
cancer. I'm just trying to help her out.
Get it, got it, good. I understand.
Really?
I feel for your mother. You have done nothing. You haven't even talked to ADRC.
She can't even lift a gallon of milk herself, man.
There's hospice. She can call those things.
Okay.
You didn't do what you needed to do. So the stay is lifted 90 days. You have a plan, you have something else, you can ask the court to reconsider, but there has to be a plan that you're making money, that you're paying back your child support. I have heard nothing except you sit on your couch all day, watching TV, eating snacks, and taking care of your mother. To what extent, I don't know, because I don't have medical records.
She's here right now. I mean,
She's here right now,
yes,
and I see her right now.
yes.
I appreciate, she's here and she's in public. Okay, she's here and she's in public, and I get that. And if that was here for sympathy or support,
Not
you're not getting it.
sympathy. It's not even sympathy. I'm sorry. Sorry.
You needed to go to ADRC. You needed to do that. You needed to figure that out back in February when we first talked about it with your mom. Back in, I don't know, 2024, 2025, 2023, when you were going to do that with the tribal member. You never even went through the process to figure that out. It's different for the tribal versus it is for the county, but similar things. You never followed through. You have to follow through. You need to be paying for the care and support of your children. It's not my responsibility. It's not Corporation Counsel. It's not anyone else here in this room. It is your responsibility. Step up. 90 days immediately can be taken into custody. Next.
I believe Miss Lemon is present for 09 PA 05 PJ.
Ms. Lemon? Is that cigarettes out hanging out of his pocket?
Yep.
Cigarettes hanging out of your pocket. You can afford to smoke, but you can't afford to pay for your kids? Absurd. Absurd. Whose phone? We will go on the record in the matter 09 PA5 PJ in re the paternity of DJL. Appearances are, we do have appearing in person, Shyla Lemon, mother. We have the state appearing through child support appearing through Corporation Counsel Stephanie Thomas Schmidt. We're here today in this matter for a sanctions hearing. Ms. Lemon, you were found in contempt and you were placed upon a purge order with purge conditions. And it appears that you have failed to comply with those purge conditions. And so that's why we're here today. Ms. Thomas Schmidt.
Yes, Your Honor. Miss Lemon was placed on a purge back in November. At that time, she was employed through the tribe. Her employment ceased that December. She did not, she made some payments after that employment ceased, at least one in January, and then a state tax intercept in February, nothing in March or April. Miss Lemon did not appear in May for a sanctions hearing, was arrested, given a bond. The custodial parent paid the bond. Miss Lemon was released from custody. She's on a pretty low order and has, with the most recent bond being posted, very, very low arrearages. Prior to June's accrual, her arrearage balance is $92, and then she owes $130 to the state. The child turns 18 in January, will graduate in May. So there's not a lot of time left that this will be accruing. I'm seeking to extend the purge for a year. I
have so many questions, The custodial parent paid her bond of $650, so he paid his own child support to go to child support.
Yep.
seriously silly. Like, what the heck? Like, then why does he care to continue to collect, to continue to have her here, to continue to have me yell at her for not doing what she needs to do if he's paying his own child support?
I don't have an answer for that one. I thought it was a peculiar situation,
Yeah.
but I think if we keep her under the purge for a year until the child graduates, and the child support ceases accruing, and if we impose but stay 15 days as a added incentive, added reminder that Miss Lemon needs to take this seriously and make a good faith effort. And if Miss Lemon is not working, to do work searches. Hopefully that can get us across the finish line.
This is weird, Miss Lemon.
I understand. I wasn't expecting my son's dad to pay it. I was in jail. I didn't know. My mom got a hold of him because I had my son Friday, and he showed up at my house and I wasn't there. I was in jail, and they both, my son and my son's dad, bailed me out. And I wasn't expecting that to happen. My vehicle blew up, so I lost my job. Didn't have a phone. I don't know. I don't have any other explanation, but
Does he want you to go to jail? Does he not?
he doesn't. No, he doesn't. He doesn't want to see me in jail. He said he's tried to drop the child support. I mean, I've been paying since I was 16.
I know, I remember your situation and all that happened there. I wasn't the judge. I don't know what happened, but he was beyond being an adult male. Well, you were 16 or 15 at being pregnant at 15. You understand to extend what Miss Corporation Counsel Stephanie Thomas Schmidt is saying with extending the purge?
Yeah. With the jail, do I have to? I mean, I have small children at home.
You're not going to jail.
Okay.
Not going to jail.
Okay.
I was saying was holding that over your head as if things don't work, this could happen.
Yeah, and I have filled out. I mean, I've filled out applications, and I've have an interview with A&W. I've had 3 with Waynes and Webster. I've been applying all over on Indeed. I don't have my own vehicle, so I rely on others, and without having my own means, it's a little bit hard. But I've been trying. It's not that I haven't. I just haven't had a way to get around or really even contact, because I haven't had a phone. And Shelley had to reach out to my other child's father to get a hold of me the one time and he brought me up here that was after I got released from jail, to get my court date. But I try. I mean, I've been trying.
The court will follow the recommendations of Corporation Counsel, and it'll extend the purge for another year with the terms stated on the record by Ms. Thomas Schmidt. And that's stipulated to by Ms. Lemon. Ms. Lemon, tragedy in all the way, trauma in all the way. I understand that, and really, really odd to have the dad of your son pay his own child support.
Yeah, I agree.
All right, so the court will adopt the recommendations.
I would just
stay in contact with corporate or with the child support. Hopefully you can get a job and you can make your purge conditions. Okay.
I would just ask that it be effective July 1st.
July 1st is the effective date.
Okay.
Thank you.
Okay, thank you.
We're adjourned.
If you're struggling with your phone, the public library has computers that you can just send them also. Okay.
Mr. Mitchell.
one's on top.
We will go on the record in the matter 10 FA 129 in re the support or maintenance of Anthony Mitchell. Appearances are, we do have Charles Mitchell appearing in person. We have Corporation Counsel Stephanie Thomas Schmidt in person. We're set here today in this matter for a motion hearing. Mr. Mitchell was found in contempt of failing to pay child support in arrears on June 5th, 2025. So we're here for a motion for sanctions. Ms. Thomas Schmidt.
Your Honor, Mr. Mitchell has done frankly better than I see from a lot of individuals with regards to his purge. He is under an arrearages only order here to pay $75 a month. Some months from July until January were lower than the $75 a month by a few bucks. And then there'd be, $28 extra for another month. So it mostly balanced out until things kind of petered off, starting to struggle in February. The February and March payments were approximately half of what was owed. And then nothing in April and May. Mr. Mitchell reported losing his last job due to some transportation situation. His girlfriend was his ride to work due to him not having a driver's license. And then unfortunate circumstances befell his girlfriend and she was no longer able to do so. And that became a struggle. But we haven't really heard from Mr. Mitchell in a while. But all told, I think the purge has been mostly successful, with some tapering off the past several months. So I'm requesting that we impose but stay 15 days jail, such that that is over Mr. Mitchell's head, not going to jail now and hopefully not going to jail at all. But that the purge be extended for 1 year to allow Mr. Mitchell to get back on the track that he had been on, and keep working toward taking care of his obligations. I think just having that added reminder that, oh no, this is what could happen, might be effective at getting Mr. Mitchell back on track, that he was on a good track for most of his purge.
All right, Mr. Mitchell, you're here without an attorney. You do have the right to have an attorney, or you can represent yourself. Do you wish to represent yourself here today?
Yes,
And do you understand what Ms. Thomas Schmidt is saying about the
yes, I
purge?
do.
And do you agree with those conditions?
Yes, I do.
And so I'm sorry to hear about you losing your job, because it sounds like you were doing really well. And you were keeping up with things and staying on track. Do you have any possibility of a job in the near future?
I've been trying to fill out applications, and like I said, transportation is a problem. But other than that, I do get per cap. I can sign out some of that for it.
Okay. Yeah. And so, I mean, I think we can easily do that. We can sign a per capita authorization form. And so if you want to do that, then that'll actually probably save you while you're looking for a job. Is there a possibility to get a job, or are you near the casino or any?
No, I'm in Cameron, so.
Oh, you're in Cameron. Oh, I thought you were coming from Hurdle.
Well, that's where I got a ride from, but
Okay. And so you're in Cameron. Are you near any businesses?
some, it's, like I said, it's just hard for transportation.
Okay. Well, hopefully with the authorization with the per capita, that'll help get you by and you won't be at risk for having to sit that jail time. The court will adopt the recommendation and the terms as stated by Corporation Counsel on the record. It is stipulated to by Mr. Mitchell. And so the sanction would be 15 days of jail but that's imposed and stayed. July 1st, the start date?
Correct.
All right, July 1st would be the start date for that. Anything further?
No, Your Honor.
All right, thank you. So what is he gonna need to do with that form?
Stop by child support, give us a little bit to get through the rest of the hearings and then Jody can,
Somebody else.
Oh,
can
no.
help him too.
Deanna or Shelley should be able to help with the per capita form.
Okay.
And they'll get it for you to fill out. I think you're pretty close to, there's a restaurant there and there's Quick Trip that shouldn't be too far. And they're usually always hiring, so might be worth an ask.
All right, thank you.
Yep.
Who next, Miss Thomas Schmidt?
If we could take Mr. Stewart?
Yeah.
Mr. Stewart. We will go on the record in the matters 07 PA 16 PJ, in re the paternity of EAS. 2010 PA 01 PJ, in re the paternity of DJP. 2002 PA 17 PJ, in re the paternity of CLS. Appearances are, we have Patrick Stewart, father, appearing in person without counsel. We have Corporation Counsel Stephanie Thomas Schmidt in person. We're set today in this matter as a request to lift the stay. Mr. Stewart was found in contempt of failing to comply with his child support obligations. He was placed on a purge order and with certain purge conditions, and he has failed to comply. Ms. Thomas Schmidt.
Your Honor, this is another sort of unique, challenging situation. Mr. Stewart has one case that is accruing support. Current support is owed at the rate of $136.43 per month, with a $25 arrearage payment ordered. And then there are two separate cases that are arrearages only, one with a significant balance and the other with a comparatively minimal balance. Mr. Stewart has made, well, frankly, he hasn't made a full payment, at least on the current support case. We've received some payment for all but 2 months of the purge. So I think that Mr. Stewart is frankly trying more than he has in a while, which is a wonderful thing. I'm very glad to see that this has been successful so far. Mr. Stewart relays that he's had some family tragedies, which has affected things, but despite that, he still managed to send in something. He had a criminal OWI related situation that he's addressed and I believe is moving forward from, and is doing education, taking classes to better his ability to earn in the future. And Mr. Stewart provided us a pay stub from a job that he recently started with Weaver Concrete, with a pay period date starting May 28th through June 3rd. So I want to be very clear that I'm very pleased with the efforts Mr. Stewart has put in thus far. But I think that this structure has been helpful. And so I'm asking to extend the purge on all three cases for a period of 1 year. I'm asking for Mr. Stewart to continue working, not quit his job unless it's to start employment at something that is a better employment, either more money or comparable money, but better benefits. Just something that would, be more significant somehow. That Mr. Stewart keep us updated with his schooling efforts, if that's something that's affecting his working, and that Mr. Stewart continue to make his payments.
All right. So Mr. Stewart, it sounds like you had a rough start, but that you are a little bit more stable and secure right now. And it seems like you're doing better.
Yes,
And so how's your new job going with the concrete?
that's going good. It's going really good. Yep. Yeah, working for John Weaver.
What?
Working for John Weaver
Okay.
Concrete.
Okay. And so it's going well. You're getting paid. You're working hours. Are you working full time?
Yes.
And when's your school?
It's online.
Online, so you can do it whenever?
Yeah, I just picked up 2 summer classes because I was lacking in the fall. There was the old man passing away, so I had to make up for some credit. So I took up a couple classes for the summer.
All right. So Ms. Thomas Schmidt, you're not asking that the court lift the stay. You're just asking to extend the purge with certain other
Correct.
requirements. And Mr. Stewart, do you agree with the new additions to the purge order?
Yeah, I believe they're all pretty much the same as before, previous, correct?
Just you can't quit your job
Yeah,
unless you have a better job
right, understood.
and you're going to continue to make your payments.
Yes,
You're going to continue to be in contact with child support
yeah, yep,
and do what you need to do.
yes, ma'am.
All right. I'm really glad to see you doing as well as you are, Mr. Stewart,
Thank
because
you.
quite honestly, you know this, I know this, you weren't doing so well years before.
Right.
So I'm really hoping that your school goes well, because I know that
Yeah.
you want to run your own business someday and you want to have the business management skills to do so.
Right,
So, all right, so the court will adopt the recommendations and extend the purge starting July 1st.
Yes.
July 1st for a period of a year. Keep it up, Mr. Stewart.
all right, thank you very
Thank
much.
you. Who would you like next? What's your name back there, sir?
Richie. I don't have you on my,
Richie, do you know your case number?
I do not offhand. I was told that I had court today from my PO last week.
for child support or for something else?
It was traffic.
Traffic.
Oh, then you have to
need
talk to
check in.
Amy. Yeah, I was wondering, I didn't know if you had kids even. But, okay, so, alrighty then, so the court will call 21 FA 26. Brianna Peterson Wilkerson et al. Versus Joseph Wilkerson. Nobody appears here today. Driving conditions are great. Nobody's called to request an extension or an adjournment for any real reason. Ms. Thomas Schmidt, what are you requesting?
Your Honor, as much as I typically request warrants in this situation, I'm not actually asking for a warrant on Mr. Wilkerson today. He was sentenced at the March sanction. Shortly thereafter, he texted that he fell off a roof and needed surgery, provided a doctor's note March 24th, excusing him from work until his medical workup is complete, whatever that means, I'm not sure. And then shortly thereafter, he communicated that he was back in the hospital for heart issues and has been dealing with that. He didn't respond to a medical release form sent the end of April, beginning of May, but then contacted that he had a cardiologist appointment mix up. He ended up back in the ER. He's still having a lot of issues. We reinstated his driver's license that we had suspended administratively to help facilitate these medical issues, but he hasn't signed a release yet. That being said, he has communicated regarding some medical issues. We have some documentation, albeit limited. So I'm asking to schedule this for the July 8th date and give him one additional chance.
All right, okay. That's fine. Sounds good. So we will put him on that date and time. I just got notice that Trent Sutherland violated his privileged release on monitor. He was immediately revoked and he was told to turn himself in. He just turned himself in. So we'll just have to redo that one a different day because he's being processed.
Okay. We can set him for the July date as well. I was going to ask for a warrant today based on his non-appearance. Prior to that, I was going to ask for an imposed but stayed sentence and extending the purge.
All right, well, I don't know how long he was on, but I sentenced him to 30 days. So if you would like to have a hearing prior to his release, we can.
Yeah, we probably should.
So I'm not exactly sure in that date and time anyway that you can check. And if you just want to set any old hearing on my calendar, we can just set it with Mary.
Sure. I'm pretty open next week.
I don't know how many days he sat. He no longer gets good time. So
yeah,
because he's been revoked. But
I'd just as soon do this when he's actually here than get a warrant and have to come back and deal with that rigmarole later.
what about June 23rd at 2:30?
I am available that day.
Aren't you with my due process hearing or no?
That's the 22nd.
Oh, I read the wrong day. I'm sorry. Because I was looking at the due process and so 2:30 on the 22nd. Does that work?
22nd.
Right after our due process hearing.
I certainly hope the due process hearing is over by then.
Oy vey, do I need to extend it? I sure will. Okay, well, I'm extending that because I'm just gonna not go over. There we go. How about the 23rd and we do 11 o'clock?
That works.
Right, 11 o'clock on the 23rd.
Okay.
Because you're right in front of that too. Oh. Okay, sounds good. What about Mr. Shoot?
Mr. Schwartzbauer, you mean?
Well, yeah, that's what I meant.
I would like a very hefty warrant.
We will go on the record in the matter 13 PA 11 PJ in re the paternity of BC. We do not have Kevin Schwartzbauer making any appearance. Quite honestly, he has a history of non-appearance. Corporation Counsel Stephanie Thomas Schmidt appears in person. Weather is good, driving conditions. We have received no telephone call from Mr. Schwartzbauer indicating that it is impossible or beyond his control and he cannot be here today. What are you requesting?
Mr. Schwartzbauer did call child support this morning and said he's working in the cities and he's not coming to court. His balance due as of the end of May, including fees, is $2,807.33. So I am requesting a warrant with a bond in the amount of $2,800. Only judge may quash.
And that's just arrears, correct?
He owes $147 a month in current support. So that amount will increase by the end of June.
Court will issue a warrant, $3,000 cash, only judge may quash or posting of the cash. He will be provided a new date and time upon posting. We are adjourned.
Just says parties may appear by Zoom.
All right, then I guess we'll try it this way. All right, can everybody hear me?
Yes.
Plaintiff can.
Kaczaleski?
Kahelski.
Can you say it again?
Kahelski. The C is silent.
Okay, Kahelski. I tried.
Hmm.
Kahelski. Okay. And do I have Miss Karen's by telephone?
Yes.
And for the record, so we can get it down, we don't have a number, 715-431-8104.
Correct.
All right. We will go on the record in the matter 19 SC 23 Barclays Bank, Delaware versus Christy Cairns. Appearances are, we have attorney James Kahelski appearing by video conferencing. We have Christy Cairns appearing by telephone conferencing. We're here on a review hearing. The court received a letter motion, I guess, from Ms. Cairns indicating that she does not believe that the judgment that has been entered against her is accurate. Ms. Cairns, did you have an opportunity? Have you spoke with Attorney Kahelski?
No, ma'am. No.
We have not talked.
Mr. Kahelski, would it be fruitful at all for you to speak with her?
Well, it would be fruitful for me because I'm not sure I understand the motion.
I don't either, and that's why I was hoping maybe you'd talk and you'd figure it out.
I don't mind trying. I really don't. And if the court is considering putting us in a breakout room, that would be fine with plaintiff. But if you're going to do that, I would like to just clear the air on a couple of preliminary matters before you send us to a breakout room.
Sounds good. And maybe I'll send you, maybe I won't. But just like you, Mr. Attorney Kahelski, I had the same view of reading her. Again, I'm going to call it a letter motion. And the very significant delay from the judgment versus today. But what would you like to clear up?
The preliminary thing is, and I'm not trying to sneak anything past Ms. Cairns or anything. I don't know. There's a lot of things I don't know and would want to know, but is the thing that's in my mind right now is she saying this wasn't her account, or it wasn't her making the payments, or she didn't work at the employer? I don't, if I can get that into my head, maybe we have some common ground to start a conversation.
All right, here's the thing. I'm going to just say, Ms. Cairns, well, first, I'm going to have you tell me that you're raising your right hand and let me know when you've done so.
I am.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, Ms. Cairns, I'm going to give you the floor so that you can enlighten both myself and Attorney Kahelski about your motion, what you mean, and what you're seeking, okay?
Yes. On April 28th, I went in and I filed a earnings garnishment debtor answer with the clerk of courts. And to follow, April 29th, I had wrote you a letter kind of explaining what is going on. I did request, due to the fact of release of earning garnishments, due to the fact of being on state help, it caused me serious financial hardship. I did request that the funds be returned to me. I also did mention that it was invalid service as far as me getting notified as far as the garnishments. I have been in touch with Kramer, not the person that's there today. There's many attorneys. And in regards to all of this, trying to find out the address, where are you sending this stuff to? And they provided me with an address that's not mine. So with that being said, I don't know why I didn't receive it, why they didn't have my current information. I did not receive notification of the garnishment of wages. I did through the third party of my payroll, UKG. They're the ones that had notified me 3 days prior to garnishment, which legally I am supposed to be notified 3 days prior to garnishment, but it is not my employer's legal responsibility. It is the debtors. They were supposed to notify me, and they did not.
Were you ever at 416 South Pine Street, apartment 22, Grantsburg?
Yes. That's my previous address, yes.
Yes, so you lived there and that was your last known address, correct?
Correct.
And at any time, did you update the court as to a change in address?
Not until then, no.
No, not until you received other information from your employer letting you know that you were being garnished.
Yeah, I didn't, yeah.
And so back in 2019, you were living at 416 South Pine Street, apartment 32.
No, I was not.
Where were you living at that time?
I was living in Frederick, Wisconsin.
Once you moved from the Grantsburg address, did you notify your credit card of your change in address?
No, I just recently moved a few months ago.
So when you moved from 416 South Pine Street to whatever Frederick address you lived at, did you ever notify your credit cards, the people with your credit cards, of your change in address?
Some of them, not all of them. I just, no, not everybody I did not notify, no.
No, and so they would have no way of knowing how to get a hold of you except for at the Pine Street address?
Correct.
Okay, all right. So are you denying that you at any time had the credit card in question?
I don't recall having that credit card nor that judgment against me in 2019. I was unaware of it till I got notified back in January of the garnishment. I'm like, where and why is this coming from? Did some research and come to find out it is from a judgment back in 2019 from Barclays, whatever it is, Barclays Bank in Delaware.
And so if I were to tell you that back in 2019, that when the Bank of Delaware, or Barclays Bank of Delaware, filed this action against you, indicating that you owed money for your credit card ending in 6668 in the amount of $3,706.31, and they sent it to, well, there was a County Road B address. Did you live in County Road B?
I did, but it was not Siren, it was Frederick.
So it was 5422 County Road B, Frederick, Wisconsin?
Correct. And on the address, it said here from all the documentation that I rounded up and found on my own, it did say Siren. And some P.O. box from Siren that does not connect to me, which means I did not receive it, which means it should have been returned to sender if I did not receive it.
But then, are you denying that on February 5th, 2019, there is a stipulation that is filed in the court that is dismissing the matter and that you're agreeing to make certain payments, and it is signed by a Christy Cairns on February 1st, 2019?
Yeah, one of the three attorneys that I had on this case did talk to me about that, which I was unaware of. So he got the documentation and showed it to me and asked me if that was my signature. And I'm like, that does not look like my signature. I pretty much scribbled my name and whatever have you. So I don't recall signing that. I don't recall making an agreement. I don't recall making all these payments, and I do not.
So are you alleging that someone from Mercerly and Kramer or Barclays Bank of Delaware forged your name?
No, I'm not saying that at all. No, ma'am.
All right. Anything else you want me to know?
No, I'm not really wanting to bring up the whole judgment thing because that's back from 2019. And I was told from a previous lawyer that we cannot open that case because it is too old. So I'm going with the current, which is the garnishment of wages, because that's the current situation we got going on here. And what I wanted to bring attention to was the fact of invalid service because I was not informed of the garnishment of wages. I was, but from the UKG, my third-party payroll, not from Barclays, whatever have you. Now, if I would have gotten the proper documents, I believe one of the attorneys had mentioned that I would have the proper documents as far as filling out a financial form. And that should have been done. That should have been submitted to the courts. That would have shown at the time that I had financial hardship. But as I was told, I talked to a couple different other representatives from the Barclays. I mentioned this caused me financial hardship. They mentioned that that's not a concern of theirs.
All right.
I mentioned that I was on Badger Care State Help. That's not a concern of theirs as well. I would believe that that would be an exemption to the garnishment order and hardship and invalid service, all three things. But maybe I'm incorrect.
Were you aware that they released the garnishment and you are asking for the return of money, but it looks like you are asking for a significant amount of money more or beyond what was even garnished?
No, ma'am. And I need to, for the court record, I checked with UKG payroll recently for confirmation and accuracy of all the garnishment that was taken. The total amount was $2,550.69 was the total garnished from my wages. And 3 payments of totaling $584.85 was refunded to me. And recently, I received a check number 002416, dated May 7th, 2026. I received it June 5th, 2026, in the amount of $1,965.84. That is the total of $2,555.69. That is the total wages that were taken, and they have been returned successfully. So I'm not requesting those funds to be returned to me because they have been.
Then why are we still here?
I don't know if I still can, but I just wanted to know if I can stay the order for garnishment indefinitely or vacate the order for garnishment due to the lack of service, and that it did cause me hardship, and I'm exempt for being on state health Badger Care.
All right, Attorney Kahelski.
Does the court mind if I field that? I mean, I'm not her lawyer. I'm not trying to give her legal advice, but I think I can answer that one question. The garnish, if the court doesn't mind.
I do not mind.
Okay, so if the garnishment is issued, it's kind of a joint obligation on the employer and the creditor to put the person on notice, and this is the facts of this case are exactly why. Sometimes we don't have an accurate address, but even if the notice is only from the employer, there's a chance to assert a defense or an exemption. We did not get that for obvious reasons, but when we did, we endeavored to, and we confirmed I think it was Badger Care, maybe Badger Care Plus, and we returned the garnishment remits. They did come in 2 different chunks as far as I can tell, and I think that was because the employer rejected our refund at one point, so we had to resubmit it. Don't quote me on that. I was on the phone with our accounting department before this hearing, and that's my understanding of it. But in any event, if she was exempt, there shouldn't have been any money taken out. But once we knew that it shouldn't have been taken out, we returned it. So that sort of answers my threshold question from back 10 minutes ago, because whether this debt is hers, I think there's plenty of information that indicates that it is, but I think it's also beyond the scope of this hearing.
Yes, and I don't think, from what I'm hearing from Ms. Cairns, I don't think she's refuting the judgment. It is too old. There is that stipulation with a signature from her. She would need an expert to testify that it wasn't. That would cost a lot of money. I think what I'm hearing from Ms. Cairns is the fact that she is exempt, and she just wants to make sure that she will continue to be exempt unless her situation changes.
All right, and that was what I was going to say originally. The process is that the look back period is 6 months. So some law firms will initiate a new garnishment every 6 months and 1 day or something like that. We don't always do it that way, but that's what the statute calls for. So to answer Ms. Cairns' question, and again, she doesn't have to believe me, I'm not trying to give legal advice. We bring these up for review approximately once every 6 months, and the review is basically, is she working and is she still exempt? And that's possibly going to continue, and I would encourage her, and again, I'm not trying to give her advice, if she's still exempt or if she has a different kind of exemption or something, all she has to do is fill out the paperwork and get it back to us.
Okay, so we need to make sure that you do have her correct address.
Yeah.
Okay. So, Ms. Cairns, your address that I have on file is 801 West 8th Street, apartment 203, New Richmond, Wisconsin. Is that correct?
Yes.
And so it is your duty and your responsibility to keep the court informed of any change of address with this case, because otherwise, and I would say, and probably Barclays Bank, because otherwise the same thing can happen. Because if you don't fill out the documentation to indicate that your situation has not changed, then this could happen again. So you're going to need to continue to apply for your exemption. As Mr. Kahelski stated, the statute says every 6 months, but it doesn't sound like they do every 6 months. They're not to the letter like that. It could be 9 months, etc. But you just need to make sure that you have your updated address with the court, as well as perhaps the Barclays Bank of Delaware. And then if your situation stays the same, you should be fine. Okay.
Okay, so my request to stay the order for garnishment indefinitely and vacate the order for garnishment is denied?
No, I'm sorry.
Well,
that's my request today, because I did get the refunded back to me from the garnishments previously. So the two requests that I am making today is that.
Technically, what it is it's plaintiff's motion to dismiss the garnishment because of the exemption. So I guess that I didn't think of it that way, but that's how it would go if this were a garnishment hearing and you proved up an exemption. I would dismiss the garnishment. So I will move to dismiss that garnishment today.
And it is granted. Thank you. But you still have to stay up to speed, Ms. Cairns, and it doesn't sound like your situation is going to change anytime soon due to your medical situation, but you just have to continue to update them once you receive the documents, if they do try and seek garnishment again, okay?
Okay.
All right. Thank you.
Thank you.
Can a driver really blame a crash on someone else when he chose to pass in a no passing zone? That's exactly the question facing this courtroom. A driver insisted he did nothing wrong and claimed the other vehicle suddenly turned into him. He even brought video evidence and argued that the road was clear and there were no signs proving he was at fault. But the police officer told a very different story. According to the investigation, the crash happened in a double yellow no passing zone, with tire marks and debris supporting the other driver's version of events. As the judge listened, he pressed both sides with tough questions, trying to determine exactly where the collision happened and who was really responsible. The defendant kept fighting back, insisting he was a professional driver and had made the pass safely. But would the evidence support his story or prove the officer right? Watch until the end to see how the judge handles this heated dispute and decides what really happened on that road.